Legal and Privacy Brief for March 31, 2026. Spanish telecom Orange fined euros 230,000 for failing to prevent unauthorized eSIM duplication. Italian banking giant Intesa Sanpaolo faces euros 31.8 million penalty for employee accessing 3,573 customer accounts without authorization for over 2 years. Dutch court orders X to ban Grok from generating non-consensual intimate images and CSAM under GDPR, the General Data Protection Regulation, violations. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief, March 31, 2026. Next section, Enforcement Actions. Italian banking giant fined euros 31.8 million for unauthorized account access. Italy's Data Protection Authority fined Intesa Sanpaolo SB a euros 31.8 million, $36 million, for security failures that allowed an employee to access the banking information of 3,573 customers between February 2022 and April 2024 without proper authorization. The regulator found serious shortcomings in personal data security due to inadequate technical and organizational measures. The bank's operating model allowed operators to query the entire customer base without adequate controls to prevent or identify unauthorized access. The affected customers were considered high risk and included well-known public figures. The bank also failed to notify customers within legally required deadlines, and the notifications sent were incomplete. Compliance action: review access control systems to ensure monitoring mechanisms can detect unauthorized queries of customer databases. Implement role-based access controls that limit database queries to legitimate business needs. Establish enhanced monitoring for high-risk customer accounts. Ensure data breach notification procedures comply with 72-hour GDPR, the General Data Protection Regulation, requirements. Source: The Record. Spanish DPA, Data Protection Authority, fines Orange euros 230,000 for eSIM duplication failure. Case X 202,300,5035. Spain's Data Protection Authority fined Orange Espagni S.A.U. euros 230,000 for violating Article 32 GDPR after the telecom company issued a duplicate eSIM card to a third party without the data subject's consent. Despite issuing an internal warning after detecting identity theft attempts, Orange employees later issued a duplicate eSIM that was successfully activated. The third party used a manipulated copy of the data subject's ID and changed the email address associated with the account. The data subject only became aware of the breach after receiving notifications about fraudulent bank transactions and losing phone coverage. The DPA found this was not an isolated incident, but a general weakness in Orange's security policy, and ordered the company to ensure its processing activities comply with Article 32 GDPR requirements. Compliance action: telecom providers should implement multi-factor authentication for SIM/eSIM duplication requests that cannot be bypassed by knowledge of customer information alone. Establish automated alerts to customers when critical account changes occur, email changes, SIM duplications. Ensure internal security warnings trigger system-level blocks that prevent employees from overriding security measures. Sources: GDP Rub X 202,300,5035. State Department reissues $10 million reward for Iranian hackers. The State Department reissued a $10 million reward for information on Iranian hackers, specifically naming two entities, Handala and Parsian Afzar Rayan Borna. The notice followed FBI confirmation that Iranian hackers gained access to FBI Director Kash Patel's personal Gmail account. Handala, which operates under Iran's Ministry of Intelligence and Security, MOAS, has claimed responsibility for recent cyber attacks on U.S. and Israeli companies, including medical device firm Stryker. The FBI has repeatedly taken down Handala websites, including several over the weekend, hosting information stolen from Patel's account. Parsian Afzar Rayan Borna is an Iranian IT company with ties to MOAS that allegedly assisted state hackers in targeting Albania's government in 2022 and engages in domestic surveillance. Source: The Record. Trump DOJ, the Department of Justice, settles Flynn malicious prosecution lawsuit for $1.2 million. The Justice Department reached an agreement to pay President Trump's former National Security Advisor Michael Flynn $1.2 million to settle his malicious prosecution lawsuit. Flynn's lawsuit had been dismissed by a federal judge in 2024 after Biden's DOJ responded to it. Flynn previously pleaded guilty to charges brought by special counsel Robert Mueller for lying to FBI agents about contacts with Russia's ambassador, and the Trump Justice Department under Attorney General William Barr moved to drop the case in 2020. Trump later pardoned Flynn. Critics argue the settlement amounts to a political payout from public funds for a lawsuit that was no longer viable, as defendants typically cannot both plead guilty and successfully claim malicious prosecution. Source: TechDirt. Russian court sentences card fraud ringleader Flint and 25 associates. A Russian military court sentenced 26 members of the cybercrime group Flint 24 to prison terms up to 15 years for forming an organized criminal group and illegally trafficking payment card data. Alexei Stroganov, known as Flint, received one of the longest sentences. The group operated between 2014 and March 2020, stealing payment card data from victims in Russia, post-Soviet countries, the EU, and the United States, distributing the data through approximately 90 online stores. Law enforcement seized about $432,000 in cash during March 2020 raids at 60 locations. Stroganov is separately wanted by U.S. authorities on wire fraud, bank fraud, and aggravated identity theft charges for a conspiracy that allegedly harvested data linked to hundreds of millions of payment cards, generating losses exceeding $35 million for financial institutions. Source: The Record. Next section, litigation updates. Louis Vuitton faces second class action over Salesforce data breach. Case 1-26 CV 702. Plaintiff Adriana Winkler filed a class action in the Southern District of New York, alleging Louis Vuitton North America failed to protect consumers' personally identifiable information from a data breach involving its Salesforce database. The lawsuit claims Louis Vuitton failed to implement basic security measures such as restricting network access, enabling multi-factor authentication, and using security tools available in Salesforce Shield, despite warnings from Salesforce and Google's threat intelligence group that Shiny Hunters was using voice phishing to gain unauthorized access. The compromised data includes names, addresses, dates of birth, driver's license numbers, and partial social security numbers. Winkler argues the breach resulted from Louis Vuitton ignoring extensive and express warnings. The lawsuit seeks certification of a nationwide class, declaratory and injunctive relief, and damages. This is the second wave of Louis Vuitton data breach litigation, following lawsuits filed in August after the breach allegedly impacted over 400,000 people worldwide. Compliance action. Organizations using Salesforce should enable all available security features, including Salesforce Shield, implement multi-factor authentication for all administrative accounts, restrict network access to CRM systems, and establish protocols for responding to vendor security warnings within 48 hours. Source: Top Class Actions. GlaxoSmithKline Boostrix Class Action Settlement, Case 2-21 CV 4869. GlaxoSmithKline agreed to settle class action claims in the Eastern District of New York that its Big Bad Cough advertising campaign misled viewers about Boostrix's ability to prevent whooping cough. The settlement benefits adults who viewed the campaign and either lived in New York or were vaccinated with Boostrix in New York between May 20, 2016 and May 20, 2020. Class members providing proof of vaccination can receive $50. Those submitting at a station without proof can receive $10. The exclusion and objection deadline is May 11, 2026. Final approval hearing is scheduled for July 2, 2026. Claim forms must be submitted by June 8, 2026. GSK has not admitted wrongdoing. Source: Top Class Actions. Slim Quick Class Action claims weight loss supplements unsafe. Case 3-26 CV 696. Plaintiffs Maria Nelson and Michelle Garza filed a class action in the Southern District of California against Platinum U.S. Distribution, WellNX Life Sciences, and WellNX Life Sciences DR on February 4, alleging false advertising of Slim Quick weight loss supplements. The complaint alleges the companies falsely claim Slim Quick increases metabolism, reduces appetite, and is made with safe and natural ingredients. Plaintiffs allege Slim Quick contains a dangerous amount of green tea extract that can cause liver injury and liver failure, and that no ingredients in Slim Quick individually or in combination safely and effectively increase weight loss. The lawsuit seeks to represent California purchasers and alleges violations of California's Consumers Legal Remedies Act, unfair competition law, and false advertising law. Plaintiffs seek class certification, at least $5 million in damages and fees and costs. Source: Top Class Actions. Supreme Court to hear pregnancy discrimination affirmative defense case, Young v. Fulton Judicial Circuit DA. The Supreme Court granted review in Young v. Fulton Judicial Circuit District Attorney's Office, a procedural question arising from a pregnancy discrimination case. The case examines whether a defendant can raise an affirmative defense later in proceedings when it did not raise that defense in the answer to the plaintiff's complaint. Jasmine Young filed a federal civil rights suit claiming pregnancy discrimination against the Fulton County District Attorney's Office, where she was deputy chief of staff. The Civil Rights Act of 1964 carves out an exemption for elected officials and their personal staff. The DA's office did not raise the exemption when responding to Young's complaint, but sought to rely on it when filing for summary judgment. The district court allowed the defense and ruled for the DA's office. The 11th Circuit affirmed. The Supreme Court's decision will affect procedural standards for when affirmative defenses must be raised. Source: Scotto S. blog. Supreme Court dissent. Jarkissi decision and jury trial rights in SEC, the Securities and Exchange Commission, cases. A Supreme Court dissent examined the Jarkissi case, in which the court held that George Jarkissi was entitled to a jury trial for SEC fraud charges. The case took nearly a decade to reach a real court after Jarkissi was prosecuted in an SEC administrative tribunal. In 2013, the SEC declined to bring its case in federal court and instead routed the prosecution to an in-house administrative law judge. The proceedings took 7 years, with no jury, looser rules of evidence, and a judge embedded within the prosecuting agency. The Supreme Court ultimately affirmed Jarkissi's right to a jury trial under the 7th Amendment. The majority worried about expanding the administrative state at the expense of constitutional rights. Dissenters warned that requiring jury trials would impair efficient regulation. Post-Dodd-Frank, the SEC could pursue harsh penalties, including large financial penalties and industry exclusion, through in-house tribunals rather than federal court. Studies showed the SEC won approximately 90% of in-house proceedings compared to 69% in federal court. Compliance action. Companies facing SEC enforcement actions should evaluate whether to demand jury trials under the Jarkissi precedent. Compliance officers should document that alleged violations were not willful fraud and consider settlement strategies that avoid administrative proceedings. Source: Scotto S. blog. Next section, regulatory guidance. Dutch court bans X from generating non-consensual intimate images via Grok. KC/13/783,613/KGZA 26120. The Amsterdam District Court banned X Internet Unlimited Company from generating and distributing non-consensual intimate imagery and child sexual abuse material, CSAM, through its Grok AI chatbot, and prohibited X from offering Grok functionalities as long as violations occur. Stichting Off-Limits estimated Grok generated approximately 3 million sexualized images between December 29, 2025, and January 9, 2026, of which approximately 23,000 depicted children. The court held that X processed personal data in its image-generating feature and failed to verify whether consent had been obtained from data subjects. The court found X had not implemented sufficient safeguards and questioned the effectiveness of measures it claimed to have implemented. The court rejected X's argument that users, not X, generated the images and that Grok was merely a tool. The EU Commission launched a Digital Services Act investigation in January 2026 into whether X met its obligations relating to dissemination of illegal content. Compliance action. Organizations deploying generative AI image tools must implement technical controls that prevent generation of non-consensual intimate images and CSAM as a controller responsibility under GDPR Article 6. Conduct DPIA assessments before deploying image generation features. Implement real-time content filtering that cannot be circumvented through prompt engineering. Establish consent verification mechanisms for generating images of identifiable individuals. Source: GDP-RUB. European Commission downplays Shiny Hunter's attack on Europa. EU portal, the European Commission confirmed a cyber attack on its Europa EU web portal, but downplayed the impact, stating no evidence showed internal systems were compromised. Shiny Hunters claimed responsibility and alleged it stole over 350 gigabytes of data, including databases, emails, and internal documents. The Commission spokesperson confirmed parts of the Europa platform are hosted on Amazon cloud infrastructure and said defense systems immediately detected malicious activities and implemented risk mitigation measures. The Commission stated affected domains were limited to Europa EU public websites and described potentially compromised data as potentially already in the public domain. The Commission declined to specify what data was accessed, how many users were affected, or whether personal data was involved. Source: The Record. Healthcare software firm CareCloud reports potential patient data leaked to SEC electronic health records. Provider CareCloud notified the SEC that a network disruption on March 16 affected one of its 6 EHR environments for 8 hours after a hacker temporarily accessed the system. By March 24, CareCloud determined the incident was material given the sensitivity of potentially affected information. The company is still assessing whether and to what extent patient information or other data was accessed or exfiltrated. Potential consequences include remediation and response costs, legal and regulatory matters, notification obligations, and effects on patients, customers, reputation, and operations. CareCloud serves over 45,000 healthcare providers and reported $120.5 million in revenue last fiscal year. No hacking group has claimed responsibility. Compliance action. Healthcare technology vendors should conduct immediate assessments of whether breaches meet SEC materiality thresholds within 96 hours. Review network segmentation to ensure compromise of one EHR environment cannot propagate to others. Prepare notification templates for HIPAA, the Health Insurance Portability and Accountability Act, breach reporting to HHS within 60 days and individual notifications without unreasonable delay. Source: The Record. Next section, Privacy Developments. White House app strips privacy consent dialogues and tracks GPS location. Security researchers discovered the official White House mobile app silently injects JavaScript and CSS into third-party websites viewed through its built-in browser to strip away cookie consent dialogues, GDPR banners, login gates, and paywalls. The app hides OneTrust pop-ups, privacy banners, consent management platform boxes, and forces body overflow to re-enable scrolling. A mutation observer continuously removes consent elements that get dynamically added. The app also contains OneSignal's full GPS tracking pipeline that captures latitude, longitude, accuracy, timestamp, foreground/background status, and whether tracking is fine, GPS, or coarse, network. A background service continues capturing location even when the app is not active. The tracking requires user permission grants, and a flag called is shared to be set to true. But the entire pipeline, including permission strings and background location service code, is compiled into the app. Compliance action. Organizations deploying mobile apps must not interfere with third-party website consent mechanisms required under GDPR, CCPA, the California Consumer Privacy Act, and state privacy laws. Apps requiring location tracking must disclose specific purposes in privacy policies and provide granular controls. Government apps should undergo enhanced privacy review before public deployment. Source: TechDirt. FBI Director Kash Patel's personal email, breached by Iranian hackers. Iran-linked hacking group, Hendala, breached FBI Director Kash Patel's personal Gmail account and published photographs, and over 300 emails dating between 2010 and 2019. The FBI confirmed the breach involves historical communications. Email verification tools confirmed several emails are authentic, including some Patel sent from his Justice Department email address to his Gmail account in 2014. Meaning the breach includes government information, despite FBI statements to the contrary. The breach demonstrates poor operational security practices by a senior law enforcement official who routed DOJ email to a personal account. Compliance action. Prohibit forwarding of work email to personal accounts in acceptable use policies. Implement data loss prevention rules that block or flag emails sent from government/corporate domains to personal email services. Require senior officials to use hardware security keys for personal accounts that may be targeted by nation-state actors. Source: TechDirt. Apple camera indicator lights provide strong privacy protection. A security analysis found Apple's on-display camera indicator system is well designed to alert users when the camera is active. While hardware indicator lights are generally more secure than software indicators because they are harder to tamper with, Apple's implementation goes beyond simplistic software rendering. The system is designed such that malicious software cannot draw over the pixels where the camera indicator is rendered to disguise camera use. The implementation provides effective protection against malware surreptitiously starting camera recording. Source: Schneier on security. Next section, policy changes. Democrats urge FCC to investigate foreign funding of Ellison's Warner Bros. Acquisition. 7 Democratic lawmakers urge the FCC to investigate Saudi and Chinese backing of Larry Ellison's $111 billion acquisition of Warner Bros., citing national security concerns. The letter highlighted that China's Tencent has a relationship with the Chinese Communist Party, and Chinese law requires domestic technology companies to cooperate with state intelligence services. The lawmakers expressed concern that Tencent's stake in the parent company of CBS News and CNN creates avenues for potential foreign influence over American broadcast journalism. The deal involves $25 billion in Saudi, Chinese, and other foreign funding. 3 Middle Eastern sovereign wealth funds, Saudi Arabia's Public Investment Fund, Qatar Investment Authority, and Abu Dhabi Investment Authority, agreed to forego governance rights including board representation. FCC Chairman Brendan Carr, who previously criticized China's relationship with TikTok, has been silent on this transaction. Source: TechDirt. Pentagon restricts press credentials and reporter access under Hegseth Defense Secretary Pete Hegseth ordered major news organizations to give up their Pentagon press room desks to MAGA-aligned outlets, with NPR's desk going to Breitbart News. Reporters were prohibited from roaming Pentagon hallways and restricted to a single corridor outside the press room. Hegseth conditioned issuance of press credentials on reporters, effectively giving military brass the right to censor or sanitize reports. Almost the entire Pentagon press corps, including AP, New York Times, Fox News, and USNY News, moved out of the building in October 2025. The Pentagon abruptly banned photographers from press briefings after Hegseth's staff found images of him unflattering. The restrictions limit reporters' ability to develop relationships with sources and obtain information that deviates from official statements. Source: TechDirt. Supreme Court to hear birthright citizenship challenge, Trump v. Barbara. The Supreme Court will hear oral arguments on April 1 in Trump v. Barbara, a challenge to President Trump's January 2025 executive order seeking to end birthright citizenship. The case involves profound constitutional questions about the 14th Amendment and whether children born in the United States to parents who are not citizens or legal permanent residents are entitled to citizenship. The executive order invokes concepts of mother, father, parents, and domicile, despite none of these words appearing in the text of the 14th Amendment or Section 1401 of the Immigration and Nationality Act. The case raises questions about whether the executive order's parent-based rules are supported by constitutional text or represent extra-textual interpretation similar to the trimester rules in Roe v. Wade. Source: Scotto S. blog. EFF Executive Director discusses privacy book on The Daily Show. EFF Executive Director Cindy Cohn appeared on The Daily Show on March 30 to discuss her book, Privacy's Defender: My 30-Year Fight Against Digital Surveillance. The book details her role representing technology users, innovators, whistleblowers, and researchers during the crypto wars of the 1990s, battles over NSA Dragnet Internet spying in the 2000s, and fights against FBI gag orders. EFF has defended civil liberties in the digital world for over 35 years, with lawyers, activists, and technologists working on issues including age verification, AI, and government surveillance. The organization is supported by over 30,000 members. Source: EFF Deep Links. Next section, Compliance Takeaways. Review database access controls immediately. The Intesa Sanpaolo, Euros 31.8 million fine demonstrates that allowing employees to query entire customer databases without monitoring creates unacceptable GDPR Article 32 security risks. Implement role-based access controls, query logging, and automated alerts for unusual access patterns, particularly for high-risk customer accounts. Treat vendor security warnings as compliance obligations. Louis Vuitton faces class action liability after ignoring warnings from Salesforce and Google Threat Intelligence about shiny hunters' voice phishing attacks. Establish protocols requiring security teams to respond to vendor warnings within 48 hours and implement recommended controls including MFA, multi-factor authentication, and Salesforce Shield. Generative AI image tools require controller-level GDPR compliance. The Dutch court's ruling against X establishes that organizations deploying AI image generators are controllers responsible for preventing non-consensual intimate images and CSAM. Conduct DPIA before deployment, implement real-time content filtering, and establish consent verification for generating images of identifiable individuals. SIM/eSIM duplication requires multi-factor authentication beyond knowledge. Orange's Euros 230,000 fine shows that security measures based solely on customer information can be circumvented. Implement automated customer alerts for critical account changes and ensure internal security warnings trigger system-level blocks that employees cannot override. Healthcare technology vendors face SEC materiality thresholds for breaches. CareCloud's 8-day delay before determining the breach was material demonstrates the need for rapid assessment protocols. Review whether patient data breaches meet SEC reporting requirements within 96 hours and prepare HIPAA breach notification templates to meet 60-day HHS deadlines. That concludes today's legal and privacy brief. From Carolina, Clear Tech. For informational purposes only, not legal advice.